Mr. Tan Chuan Ao, Deputy Secretary General, Operations, Ministry of Multimedia and Communications, Malaysia. The Honorable Mr. Stephen Sim Chee Keong, Deputy Minister for Youth and Sports, Malaysia. Dr. Meng Kwok Lim, Advisor for Communications and Information, UNESCO Office in Jakarta. Encik Abdul Muiz Shafi, Acting Director General, Radio Television Malaysia. Distinguished guests, panel of speakers, delegates, members of the media. A very good morning, selamat datang. Welcome to the IPDC Talks in Kuala Lumpur themed Benefits and Challenges, Access to Information in Malaysia. We are indeed honored by your presence, as this is the very first time that the IPDC Talks are being held in Malaysia. Allow me please to call upon Dr. Meng Kwok Lim, Advisor for Communications and Information, UNESCO in Jakarta, to deliver his welcome address.
Good morning, ladies and gentlemen. Honorable Deputy Minister for Youth and Sports, Mr. Stephen Sim, Deputy Secretary General of the Ministry of Communication and Multimedia, Mr. Tan Chuan Wu, Deputy Director General of Radio Television Malaysia, Tuan Haji Abdul Muiz Shafi, Excellencies, Ambassadors, distinguished guests, ladies and gentlemen. Welcome to this IPDC Talk 2018 at Kuala Lumpur on access to information, benefits and challenges in Malaysia. This is the first time that the IPDC Talk is taking place in Malaysia. And we are very happy to be able to collaborate with the Asia Pacific Institute for Broadcasting Development, AIBD, as well as RTM to bring you this very educational and interesting event. IPDC stands for the International Program for Communication Development. It is the only multilateral forum in the UN system that brings together international communities to discuss and promote media development, as well as a laboratory of ideas on cutting-edge issues, on communication issues. It is a program within UNESCO because UNESCO is the UN organization with a specialized mandate to promote freedom of expression, and with that encompasses access to information, freedom of the press, and as well as safety of journalists. Access to information is something very close to the heart of what UNESCO does. It is written into our very constitution, which states that we must promote the free flow of ideas and images. Indeed, without access to information, how could we achieve that ideal? How could we achieve the free flow of ideas and images, regardless of frontiers? Meaningful access to publicly held information has been recognized as one of the criteria for achieving the Sustainable Development Goals by the year 2030, which all nations, including Malaysia, has signed on to. In particular, Goal 16 of the SDG seeks to promote a just, peaceful, and inclusive society. And that must ensure the public has access to information. One of the ways that UNESCO promotes this fundamental freedom is through awareness-raising events such as this IPDC Talks. But ladies and gentlemen, this event is not just limited to the people in this hall. While we are doing this, other events around the world are also taking place. We are in fact connected to a much larger global community that is advocating for access to information. Similar events are taking place elsewhere in the world, in Latin America, in Europe, in Africa, and in the Arab states, as well as other parts of Asia. It is also designed to coincide with the International Day for the Universal Access to Information, or more commonly known as the Right to Know Day, which falls on this Friday, on the 28th of September. So, distinguished guests, we are here today with 6 experts, 3 international and 3 Malaysian, bringing us the perspectives and the point of view from academia, from the civil society, and from national institutions, both local and global. I'm very excited about this talk today, and I'm sure that we will all leave this P.Ramlee Hall today all the wiser about access to information and much more familiar with these fundamental human rights. And with that, I thank you and I wish you a fruitful IPDC Talk 2018. Thank you.
Thank you very much, Dr. Ming, for that welcome address. Ladies and gentlemen, it gives me great pleasure now to call upon Mr. Tan Chuan Au, Deputy Secretary General, Operations, Ministry of Multimedia and Communications, Malaysia, to deliver the opening remarks of the Deputy Minister of Multimedia and Communications. Mr. Tan.
First and foremost, I would like to convey to you the apologies of the Yang Berhormat Tuan Adeline Shazli, Deputy Minister of Communication and Multimedia, for not being able to be here this morning to speak to you all in person in this important event. Yang Berhormat has to attend the opening of the State Legislative Assembly, which is scheduled in this morning at the same time. Anyway, I'm asked to deliver the opening remarks on his behalf, so may I proceed with his opening remark. The Honorable Stephen Sim Chee Keong, Deputy Minister of Youth and Sport, Tuan Haji Abdul Muiz bin Shelfi, Acting Director General of Radio Television in Malaysia, Dr. Ming Kwok Lim, Advisor for Communication and Information, UNESCO Office in Jakarta, distinguished guests, ladies and gentlemen, a very good morning to all of you. It gives me great pleasure to welcome you to this IPDC Talks event on access to information, benefits and challenges in Malaysia. It is truly an honor for me to be among so many dignitaries comprising academicians, human rights advocates, the legal fraternity, the media, and the diplomatic corps to address the issue of access to information in Malaysia. The IPDC Talk is an initiative of UNESCO International Programme for Development of Communication, in short, IPDC, to mobilize the international community to discuss and promote media development and access to information around the world. We are creating a kind of historic moment here today because for the first time in this event is taking center stage in Malaysia with the cooperation of Asia Pacific Institute of Broadcasting Development and Radio Television Malaysia. Ladies and gentlemen, whether we realize it or not, access to information is connected to all of us. Every day, choices of citizens are relying upon the accuracy, timeliness, quality, quantity, and relevance of information released by the custodian, in particular the government. The fundamental right to information is enshrined in Article 19 of the Universal Declaration of Human Rights since 1948. It states, everyone has the right to freedom of opinion and expression. This right includes freedom to hold opinion without interference and to seek, receive, and impart information and idea through any media and regardless of frontiers. The International Covenant on Civil and Political Rights further expand on this basis right in 1966. Ladies and gentlemen, discussion on access to information are most often approached from the viewpoint of legal and human rights. As a taxpayer, citizens are legally entitled to know how the government makes decisions and what the public information it holds. Without the right to know, one loses the ability to make informed decisions regarding who they elect as officials to represent them in matters of governance. Therefore, laws that deny the right of access to public information or that turn public information into private property of the government do not just negate the individual's right to freedom of information, but also hampers the fulfillment of the individual other democratic rights. The media, which is often regarded as the watchdog for the society, must certainly have even more interest in promoting access to information. This is especially true to investigative journalism that probe irregularity and bring about open debate on issues of public interest. News coverage and analysis must be fully researched and thorough, keeping in mind the aspect of neutrality and the media ethics when covering the news stories. Foreign newspaper and magazine, satellite television, news channel, and the internet may occasionally supplement local sources of information. However, Malaysian media should take the lead in providing credible news with the right sources. The internet was initially hailed as the solution to information wars, especially in delivering the independent news and view not found in the print and electronic media. To some extent, new technology has indeed widening plurality of view and free expression. For example, the emergence of websites that highlight the view of various political parties and NGOs. Ladies and gentlemen, we should consider access to information from a holistic point of view. It is more than just having a law. In many ways, having a law is just the first step in developing the culture of transparency, changing the mindset of civil servants from that of secrecy to proactive disclosure of public information is vital. And equally important is to raise public awareness and knowledge on the importance of access to information. In this regard, the IPDC Talks Kuala Lumpur 2018 is the most timely event that is contributing to the rising public awareness of the benefits and challenges of access to information in Malaysia. With those few words, ladies and gentlemen, I wish that all delegates a successful and fruitful conference, and I personally look forward to a highly educational event. Thank you very much for your attention.
Thank you very much, Mr. Tan Chuan Ang, for delivering the opening remarks of the Deputy Minister of Multimedia and Communications, the Honourable Mr. Edin Shazli. Our first speaker is the Honourable Mr. Stephen Sim Chee Keong from Malaysia. Mr. Sim is the Deputy Minister for Youth and Sports. He graduated from the University of Malaya with a degree in computer science. In 2012, he was named as a young global leader by the World Economic Forum. He is an avid writer and has published 2 books titled The Audacity to Think, An Invitation to Rethink Politics in 2012, and more recently, Being Malaysia. Please welcome Mr. Stephen Sim Chee Keong.
3 books actually. The 3rd book was a book on poetry, which was why it didn't register. It is already a win when we see Cynthia Gabriel and Asmi being invited to an RTM show. So, recently, I bought my first copy of Serat Centini. For those of you who know the book, it is popularly known as the Kama Sutra of the Javanese world. Javanese Kama Sutra, 200-year-old text of this, a great work of the Malay world, with description of Javanese kung fu, such as kumbang menghisap madu and kedudukan ular mematuk. I'm not sure whether you'll pass RTM censorship. But when a learned friend came to my office and saw my very thin single volume, it's a 12-volume work, but when a very learned friend came to my office and saw my very thin version, single volume thin copy, he asked, where are the rest of them? I said, well, in the census dustbin. Somebody said, I think it was Article 19 when we were doing research for this speech, they said that freedom of information is oxygen to democracy. I think this is probably one reason. Too much oxygen burns. I think all of us can agree that there are certain things which should be confidential. Cabinet discussions, for example, this is a well-known argument, should enjoy a level of confidence, of trust, so that honest opinions can be deliberated in the meeting without the fear of someone's view being manipulated because of irresponsible expose. Of course, the word confident and confidential, I look it up on the net. They share the same Latin word, which really means to have full trust. Matters of national security, public safety, crime prevention, detection, all these are sensitive information which require some level of secrecy at least. And of course, we do not want our personal information from hospitals, whether government or private, from telcos, to be exposed without our consent. In our time, there is a real tension between fighting breaches of personal information, personal data, versus trying to unlock government secrecy. Because, like it or not, in this age and time, personal data, personal information, and public information, they are more intertwined than we can imagine. And of course, we live in the time of what we call the age of explosion of information, where information is being shared almost on a minute-by-minute basis. We share personal views and opinions on football and politics. There is partisan news and propaganda. There are stories online about alien invasions and dragons being discovered. There are so-called expert views on the danger of vaccination. We have advertisements ranging from regular products and services to pseudoscientific alternative medicine, get-rich-quick scams, to outright alternative facts. The net effect is that we, as a society, we become overwhelmed with trying to figure out falsehood from truth, or truth from falsehood. Because of this so-called freedom, we spend more time sieving through information, not knowing for sure who or what to trust anymore. And I wrote this little quote in my book, Being Malaysia, second book. We are chained by our own freedom. We have become less free as a result. But having said all that, are we, or is this government, is this administration going to revert to business as usual, like in the previous government? To me, Cynthia is waiting. To me, the answer is a clear no. What is business as usual? When I was running a think tank in Penang, I'm just going to describe to you what is business as usual. I requested, or rather we, the think tank, requested information as neutral and as safe as statistics on Penang import and export activities. One would imagine this is a very, this would be one of those regular day-to-day requests. But to our surprise, our request, our application was rejected by the previous government. And the reason given, because previously, when this information was given, it was manipulated or misinterpreted by the public. Hence, the government decided not to give them out anymore. Similarly, we have seen, and I myself have experienced in Parliament, when asking for statistics and data on sexual crimes. Women NGOs have come out saying that this information were denied to them. The fundamental problems in our time today with information, especially with government information, is that whether at the local, at the state, or at the federal level, information is by default a secret. And this is no longer just words of the law represented in legislation such as the Official Secrets Act, it is, or rather it has become a culture within our society, especially within the civil service. I was involved when the Penang state government created the Penang, or the Freedom of Information Enactment in Penang. But at the inception of the legislation in Penang, the state legal advisor herself, former state legal advisor herself, actually opposed to the new law because she claimed that it was ultra-virus the Constitution. It was against the Constitution. Information is seen as a privilege, and this can be clearly seen. I'm going to show you an example. This is a comparison between the original draft proposed by the state legal advisor after we forced her to present the bill at the State Assembly, and compared to the current version, or the version adopted by the Penang legislator. The original draft said it's an enactment to provide disclosure of information for public interest and opportunity on access to information made by every department of the state government, and so on and so forth. We insist, we as in my team and I, we represented DAP as a party to appear before the select committee, and we insist that opportunity on access is not enough. It must be right to access. And so that was adopted by the legislators. Section 5.1 said any person may be given access. We thought, oh, it's a legal language, but we wanted something stronger. So we proposed that the word may be changed to must, subject to the exemption later, and the legislator adopted it. So you can see the attitude or behavior of the government towards information. By default, information is seen as a privilege. But freedom of information must not be a privilege. It should be a right. In fact, in my opinion, freedom of information legislations, tools such as the FOI, should be a measure of last resort. Government information should be, by default, easily available and accessible for public consumption. While on the other hand, exemptions must be extraordinary, limited, and specific. We need to shift as a country, as a nation, as a society. We need to shift from a culture of secrecy to a culture of openness and transparency when it comes to government information. Of course, this is about big things like human rights, but it is also about helping everyone to make sense of our world better. Imagine if data of our city is being published, traffic information, public transport tracking, municipal spending, city hall budget. Not only people outside of the government can better understand the activities and behavior of our city, but think about the potential in this smart app generation. Someone may create an app if we open this data to them at the government level. Someone may create an app to tell you about traffic situation or to recommend public transport routes. Or perhaps an app to monitor real-time tax revenues as well as expenditure of the local government. And I think civil society, both civil society and businesses, can benefit from such technology, especially to make investment or advocacy decisions. Or allow me to introduce to you this very brilliant platform by my friend CNOW Project, a tech group advocating for freedom of information in Malaysia. For many years now, they made parliamentary answers given to MPs available as searchable documents online. This has never been done. And their website, Parliamentary Documents, under CNOW Project, is a treasure trove for researchers, including our stole from the government itself. Our legislation, such as the OSA's, Official Secrets Act, is almost 50 years now. It is time for us to review such law to incorporate new thinking, progressive values, as well as new behavior towards information of our time. Allow me to end this by recapping on these three thoughts. Number one, freedom of information must be the default mode of government. Number two, we agree that government must have certain level of confidentiality, but the point is definition of official secrets must be extraordinary, limited, and specific. And finally, there must be a clear shift in our culture, the way we handle information. While we grant access to information, protect whistleblowers, we must also ensure some kind of protection against false and irresponsible use of information. Thank you very much.
Our next speaker comes all the way from Sri Lanka. She's Ms. Casali Pinto Jayawardena. She's the Commissioner for Rights to Information, Commission of Sri Lanka. She's a constitutional lawyer who has litigated in Sri Lanka's appellate courts, including in notable cases, expanding the protection of civil liberties, and has challenged the Sri Lankan state before the United Nations Human Rights Committee under the International Covenant on Civil and Political Rights for non-conformity to international legal safeguards. She has been in the forefront of media law reform, including on contempt of court and right to information. Ms. Casali Pinto Jayawardena.
Good morning, everyone. I'm very happy to be here in Kuala Lumpur after 10 years. My last visit was 10 years ago, and I find that I feel as if I'm back at home again when I come. Always I feel this when I come to Kuala Lumpur and to Malaysia. Now, let me talk of access to information in Sri Lanka, or as we refer to it, the right to information. And I agree very much with the previous speaker that this is actually a right. So it is not a privilege, it is very much a right. And let me really illustrate the potency and the power of right to information in Sri Lanka by two examples. Now, the Rti Law, as we refer to it, came out of a 15-year-old struggle in Sri Lanka, and it was enacted in 2016 August. It has been ranked the third best globally and the first in South Asia. But to that, the law is just in theory. The theory and the practice are two very different things. Now, when the act was enacted in August of 2016, we took only 6 months to operationalize the act in February of 2017. And on the very date of operationalizing, February 3rd, in the eastern province of the country, which is a very remote province affected by war for the last 3 decades, a group of mothers of Tamil ethnicity, as many of you in the hall know, Sri Lanka has one majority ethnicity, the Sinhala ethnicity, and you have Tamil and Muslim ethnicities as the minority ethnicities. Now, in the eastern province, 15 mothers of Tamil ethnicity took copies of the Tamil Right to Information Act and went to police stations in the eastern province, waved the act in front of the faces of the policemen in the police stations, and wanted to know what had happened to their children who had been disappeared during the end stages of the conflict in 2009 between the Liberation Tigers of Tamil Eelam and the government of Sri Lanka. Now, this was an unprecedented situation. The police officers were completely unaware that an act like this had been enacted. And moreover, it is now changing a little bit, but at that time, many of the policemen serving in the eastern province and in the northern province were really of Sinhala ethnicity, so they couldn't understand Tamil. They couldn't read the language, they couldn't understand it. So when the Tamil mothers came with the act, they were completely nonplussed. And they said, we can't understand, we can't understand what you're saying, we can't read this document. And the mothers ended up explaining to these policemen in Sinhala, which they knew, because they had to, what the act was all about. What gave them the right to come to the police stations and ask for these answers about their children from the policemen. Now, to many, it may seem a fairly mundane occurrence. You go to a police station, you file an inquiry, But this was not mundane. It was extraordinary, because for 3-4 decades, to survive in the north and east of Sri Lanka, one could not ask questions. If you had to survive, you should not ask questions. And this was a very definitive empowering of women, not only to go to a government agency, to go to the police, which was extraordinary, and to ask for answers. Now, what happened therein was that as a result of their asking these particular questions, they initiated an inquiry into the disappearances, which is now ongoing, and that process is taking place. There's a second example that I just want to illustrate to you about, again, to show what a difference RTI and access to information has made in Sri Lanka. And this is regarding an application filed to the RTI Commission, of which I'm a member. The Commission is an appellate body. It considers information requests that have been denied by the public authorities. And an appeal was filed before the Commission by the Pilots Guild of Sri Lanka, that is a national pilots organization, asking for information regarding the salaries of the CEO of Sri Lankan Airlines, the country's national carrier, and other top executives, and benefits given to them, as well as documentation relating to certain aviation agreements that have been entered into between Sri Lankan and other aviation firms. Now, there was a background to this here. This was in the context of gross corruption in the national carrier for the last 2 decades or so, whereby once profitable airlines had been run virtually to the ground as a result of very bad management of the airline, major corruption by all political parties and by governments in Sri Lanka, and it was running at a loss. It was actually being run, and it is run now through funds by the Treasury. Otherwise, it would be bankrupt. Now, Sri Lankan Airlines resisted the information asked for with all guns blaring. So it came before the Commission with a battery of corporate lawyers. It raised every trick in the legal book. It raised points of law, substantial as well as procedural, and said we cannot give this information. After 6 months of very heated hearings, actually, the Commission handed down a 25-page order 2 months ago, whereby it ordered Sri Lankan to give all the information asked for, excepting one, which was concerning negotiations between Sri Lankan and Airbus SAS that was ongoing at the moment. And after a month, Sri Lankan complied with the information direction by the Commission. It gave all the information. In between that hearing, the CEO of Sri Lankan took early retirement. The entire board of Sri Lankan Airlines changed. A new board was put into its place. And there was major public furor around the fact of the national carrier and all the corruption that had come to light. So now 2 examples that I've given you. One is from the villages, and one is at the highest level of corporate accountability, showing how RTI has actually directly benefited the people in Sri Lanka. Now, apart from these 2 examples, there are, of course, many more. The Commission itself is also a very new Commission. We've been in operation for just 1.5 years. I'll give you some more details about what the Commission is all about a little bit later. But we've handed down hundreds of orders up to now, and public authorities in Sri Lanka have actually complied with the Commission's directives. There's been no public authority that have said, we are not going to obey you, we are going to resist you, we are going to the Court of Appeal, we are not going to give you the information. They have not really said that. They have all complied. There are 2 reasons for this. One is that the Commission itself, when handing down the orders, don't actually order information release in all the cases. There's a fine balance being struck between the right to information and the right to privacy, to national security, to other issues that must be also considered. So there's a balance between the 2 rights that are very carefully engaged in by the Commission, because we are aware of the need that the RTI Act must not be resisted by the establishment or by the public servants. That's a very strong concern that the Commission has always been having. The second issue is that our orders are also very carefully reasoned. We don't just give administrative orders or 1 paragraph saying release the information. There are legalistic reasons being put down as to why information ought to be given or should be not given in the first instance. So among the other information released by the Commission and due to the Commission's orders are commissions of inquiry reports. Now, Sri Lanka has had a habit, I don't know how it is in Malaysia, Sri Lanka has had a habit where the President appoints commissions of inquiry to look into various issues of high-level fraud, corruption, disappearances, human rights violations, and the reports are never released. Now, in one particular case, there was a very suspicious death of a cabinet minister 10 years ago, and the President appointed an inquiry committee to look into this matter, to inquire into the matter of this particular person's death, and the report was never released. It was hidden away. So there was a request made to the Commission that people wanted a copy of the report, and the Commission then went on an inquiry. And the report is missing in the National Archives. It was missing in the Office of the President's files and drawers. Ultimately, it was found deep in the bowels of the Criminal Investigation Department, the CID, and it was then released to the public. Then there are other examples, and I could really give you many, many more examples, ranging from procurement, from tender issues in particular state entities, so on and so forth. We have released instances of migrant workers' treaties being entered into between the government of Sri Lanka and other governments like Qatar, Kuwait, Saudi Arabia, so on and so forth. We have released draft laws. In Sri Lanka, there's a practice whereby laws, when they're being drafted, are not really released to the public. They're released only when the matter comes up before Parliament, and then only within 2 weeks of the draft bill, you have to challenge the bill in the Supreme Court. Otherwise, you have no way of challenging it after enactment, even if the bill is unconstitutional. So here, in this case, 2 bills that people wanted access to. One was in reparations to victims of the conflict in Sri Lanka, and the other was the bill related to the draft bill related to disabilities of people. Both bills were released after the Commission issued orders. Now, let me just say this also. The Commission's orders that I'm talking to you about at this point of time represent only a percentage of the right to information requests in Sri Lanka, because they come to the Commission only when that has been refused by the information officer at the lower level. During the first so many months of RTI law being enacted in Sri Lanka, the amount of information requests filed each day were 100. More than 100 were filed each day. And RTI became like this thing where you went to it for everything that you couldn't find. Normal service delivery, government permits, car permits, land deeds, whatever. It was basically, sort of seen as a panacea for many, many years in Sri Lanka, and people kept going to RTI Act and filing these requests. Now, a little bit of the history, though I won't go into it in detail here. In Sri Lanka, the RTI struggle was not a people's-based struggle like in India, for example. It was led by a group of lawyers, academics, and activists in Colombo, who basically started their process 15 years ago. And there was a bill in 2003, 2004 that was passed to a parliament but not enacted. And then ultimately, when the government changed in 2015, we had the struggle for RTI coming back into the process again. Earlier, during the Mahinda Rajapaksa decade, where we had a president and his brothers controlling about 99% of the national budget, there was no possibility of information law in any sense whatsoever. The president at the time actually said that we don't need an information law, that he is the fount of all information, and anybody wanting information could come to him and ask for information. That was the extent of the state resistance to information that we had at that time. In 2015, there was a new sort of government in place, and they said, okay, we have to enact this law, and then we were called upon to draft a law and give it to the government, and Parliament actually passed the law with almost 99% of what we wanted. So in theory, the law has been quite proactive and quite good. In practice, also, it has been quite good, as I explained, but of course, there are challenges, and I'll talk a little bit about the challenges. So the first challenge is this. As I said earlier, Sri Lanka did not have a people-based RTI movement. It was a more elite kind of movement in the city. But the RTI law has been used very much by ordinary people in Sri Lanka in very remote places, in very remote parts. So that is a positive factor. But because it has not had a people's movement around it, the possibility of governmental change in the future, with a new government coming in, what could happen to the right to information law in Sri Lanka is very much a problem, because ultimately what will foster and keep a law strong is a people's pressure and a people's movement around it. It must become part of a civic democracy strategy in the country. In Sri Lanka, it is not yet happening, though it is going on towards that, is yet not happening. Now, the second concern that I wish to mention is the fact of threats being leveled against people using the RTI. So you do have instances where communities and individuals are using RTI, are being threatened by particular sectors of the government. Not many, not all, but particular sectors of the government. And the threats are coming in very indefinite ways. For example, they don't say don't file RTI, but what they say is, well, we're not giving you a benefits if you file RTI. So it's very indirect. They're not really challenging directly. And then we've had instances where journalists who have used RTI have had intelligence reports being maintained on them from the security forces. So the culture of change, as was mentioned earlier as well, is important to note that a law cannot really change a culture. That has to be more gradual. And in Sri Lanka, this culture is being changed, but still we have a long, long way to go. So if the possibility or the phenomenon of threats being leveled against information requesters become widespread, then we will certainly have a problem as we go on. The third point that I want to mention is, again here, the law has been used and drafted in a way that is very adversarial, it's very challenging. You go to a government office and you challenge them, and you say, give us the information. But the importance of RTI comes in proactive disclosure. It comes in voluntarily giving the information. The government voluntarily realizing that it's good for its own culture and is good for its own establishment to give the information. And the proactive disclosure element of the Sri Lanka's information regime is extremely weak at the moment. That has to be really developed. I would like to conclude by making one concern very strongly felt. As Sri Lanka really goes on in its information path in the future, we really need to look at ways and means in which information is considered to be part of an overall general discourse among the people in the country. We have had instances where information release has led not only to the mere release of the information, but people challenging governance and government itself. So for example, we had a very good instance recently in the North Central province where there had been major corruption in the building of tanks and roads in that particular area. And because of RTI, because villagers filed RTI applications, they discovered the fraud and the money was returned to government. The public officials were actually dismissed from their office and they built the tanks and the roads all over again. Now, this was a good example of the people coming together from a very remote area of Sri Lanka and actually getting on the streets and demonstrating and asking for things to be changed because of right to information. We need to find that happening in a lot more, in a lot more diverse instances in Sri Lanka, not only in one instance, because that is the only reason why RTI law in Sri Lanka will be safeguarded in case of any changes in the future, politically or otherwise. Thank you.
Thank you very much, Casali, for sharing with us the right information, the Sri Lankan experience. From Sri Lanka, we have our next speaker, who comes from Singapore, Mr. Amos Toh.
Hi, good morning, everyone. My name is Amos Toh, and I am a fellow at the University of California Irvine School of Law, and I also work with the United Nations Special Rapporteur on the right to freedom of opinion and expression. UN Special Rapporteurs are appointed by the UN Human Rights Council to monitor and report on human rights issues around the world. The right to freedom of opinion and expression is a well-established human right under international law, as well as in virtually every national constitution around the world. Article 19 of the Universal Declaration of Human Rights states that everyone shall have the right to freedom of opinion and expression, which includes the right to seek, receive, and impart information and ideas of all kinds. When we think about violations of the right to freedom of expression, we might think of charges of defamation and sedition against journalists, government critics, and the media. We might think of censorship of government news websites, journalists. We might think of internet shutdowns, and we might even think of social media censorship. We might focus less on the right to receive information from government authorities and the right to know what is going on behind closed doors with regards to public affairs and government activities. But I'm here to argue that the right to access to information is a key component of freedom of expression. Without access to information, there can be no right to criticize, report, or protest. This is because if we don't know what's going on behind closed doors when government institutions are operating, or how institutions of power are functioning, then secrecy can be weaponized to silence criticism, journalism, and protest. My home country, Singapore, is ranked 151st out of 180 countries on the World Press Freedom Index, which is compiled by the civil society organization Reporters Without Borders. But Singapore is, by many accounts, a peaceful country. There is very little record of any violence against journalists and even its harshest critics. There are no arbitrary executions, no show trials, no sudden disappearances. But repression doesn't have to be overt. It can be invisible, orchestrated in the shadows. Its effects can be deeply felt, but its root causes uncertain. Kirsten Han is a well-established human rights advocate and journalist in Singapore. Her reportings and writings have been featured in publications and news outlets as diverse as Al Jazeera, The Guardian, and ABC News. Her reporting and writings and analysis have raised probing critiques of the Singapore government as well as its laws and policies. In 2016, her husband, who is not Singaporean but had a job offer in Singapore, was told by the Ministry of Manpower that he was not being granted permission to work in Singapore. Although this process of going through the application materials and arriving at the decision and notification on approval to work usually takes 7 days, it took the ministry 2 months to get back to him with its decision not to proceed with his employment pass. This doesn't make any sense on paper. Mr. Han's husband is highly qualified and had a job offer from a large multinational corporation. All the paperwork seemed to have been filled out correctly, and every rule on the book seemed to have been followed. When they asked the ministry for an explanation, this was the response they got, and I'm going to read you an excerpt from the email response they got. We would like to reiterate that each work pass is assessed on its own merit in consultation with the relevant government agencies. We are unable to disclose details of the rejection. Not a lot of information there. So they followed up with some questions, and this was the response that they received again. Our position on this application has not changed. We regret that we are unable to assist any further in your inquiries. This means that Ms. Han's husband can remain in Singapore on visit passes, but he cannot work. Visit passes must be renewed every 6 months. The company that offered him a job had to find someone else. Till this day, Ms. Han and her husband can't make sense of these rejections. She wonders whether it has anything to do with her writings on Singapore, whether it has anything to do with her advocacy against the death penalty in the country and her advocacy and reporting on the state of human rights in Singapore. Ms. Han's predicament is not an isolated incident. Tan Tan Hao, who is a renowned Singaporean playwright, has blogged about how in the last 3 or 4 years, a growing number of educators, teachers, academics, and researchers have found that they have been let go from their positions at work, told that their services are no longer needed, their employment passes denied, their job offers mysteriously withdrawn. What they all have in common with Ms. Han is that they are all, to some degree or another, active participants in public discourse in Singapore. The question is, are they experiencing reprisals as a result of their critiques of the government? Like Ms. Han, they have their suspicions, but they cannot know for sure. And this suspicion, this seed of doubt that cannot be confirmed, is precisely the point. Censorship doesn't just happen when a critic is thrown into jail, or when a media outlet is shut down, or when somebody is charged and convicted of sedition or defamation. The mere prospect of state-sanctioned backlash for something you say that doesn't quite toe the line of acceptable politics, that mere prospect is enough to intimidate or censor. It makes you think twice before you speak. What jobs am I putting on the line? What relationships might suffer as a result of my expression? This is what Ms. Han calls the silhouette of oppression. And this is where access to information comes in. Access to information is a powerful antidote to the silhouette of oppression because it brings government repression or oppression out of the shadows. It prevents government agencies and their deliberations from becoming black boxes. It is well accepted under human rights law that states have an obligation to protect the right to freedom of information under the law. So this usually comes in the form of freedom of information legislation, such as the Freedom of Information Act in the United States. But the Special Rapporteur has observed that having laws is not enough. There must be a transformation of political and bureaucratic culture based on fundamental values of transparency and public participation. There must be an independent legal profession, and there must also be an independent and impartial judiciary. Institutions that can project coercive power, such as law enforcement and intelligence agencies, must be perpetually willing to confront their propensity for violence and intimidation. Taken together, this is what the Special Rapporteur has called the basic infrastructure of protection for access to information. So that is what happens, that's what's required for a regular culture of access to information. But what if that culture doesn't work? What if the proper legal channels and the proper channels for ensuring the flow of information between the people and the government break down? Sometimes government agencies are so steeped in a culture of secrecy that there can be no information out there about what that particular agency does, and there can be very little accountability. Courts exercise very powerful oversight and accountability functions, but they cannot exercise such functions in the dark. The media cannot focus public scrutiny on what it cannot see. In these situations, our last line of defense are the brave individuals that come forward and break the walls of official secrecy and silence so that we, the people, can hold power to account. These individuals are commonly referred to as whistleblowers, and they are important actors in facilitating the right to access to information. In the United States, one of the most prolific whistleblowers in recent memory is Edward Snowden, who was a former contractor with the National Security Agency, the key intelligence agency in the United States. His disclosures of NSA documents revealed to us that both the United States as well as major global powers around the world are conducting mass surveillance operations around the world. Snowden not only encouraged a much-needed conversation about how our privacy should be protected online, he also provided a glimpse into the complex array of public and private actors that mine and collect information about our digital lives and uses that data to project influence and control over global and domestic politics, as well as international economic relations. Mr. Snowden belongs to a long tradition of whistleblowers that have provided opportunities for the rest of us to speak truth to power. But many of these whistleblowers do not have the same profile as Mr. Snowden. Many of them struggle to make their concerns heard. They also face tremendous personal and professional risks, like Mr. Snowden. Take, for example, a former Australian intelligence officer as well as his lawyer, Mr. Bernard Collery. They are currently being charged for allegedly disclosing intelligence secrets in Australia. What was their offense, you might ask? In 2006, their disclosures or alleged disclosures had apparently revealed that the Australian government had planted bugs in government buildings in Timor-Leste while they were negotiating a deal to carve out oil and gas reserves worth billions of dollars. This information of the covert surveillance operation conducted by a foreign power in Timor-Leste not only cast doubt on the validity of the initial agreement that was reached, but it also raises very serious human rights concerns. For these alleged disclosures, they are now being charged with crime. Another whistleblower that has faced tremendous personal and professional risk is Chelsea Manning, who leaked military and diplomatic documents from the United States showing the horrific toll of US war in Afghanistan and Iraq. For her disclosures, she was sentenced to 37 years in prison. Former President Obama commuted her sentence after she had served for 7 years. Treating whistleblowers as criminals doesn't just hurt them, it also hurts us, the public. Without these disclosures, we will not necessarily have the information that is required for us to have candid conversations about the leaders we want to elect, about the kind of society we want to live in, about the democracy that we want to cultivate. It is true that whistleblowing is messy, complex, and contested. Whistleblowers have been accused of making disclosures for personal gain. making too many disclosures, or even sometimes too little, or for placing the safety and security of others at risk. But these arguments are not a bar against whistleblowing. Instead, they simply illustrate that when we enact protections for whistleblowers, when we enact protections for the public's right to know, we must take into account legitimate interests for protecting information. In this spirit, the Special Rapporteur has advocated for protections to be enshrined in law for whistleblowers, especially when they have a reasonable belief at the time of those disclosures that the information that they are disclosing is constituting evidence of harm to the public interest. This would encompass evidence of government corruption, human rights abuses, harm to the environment, and government fraud, waste, or abuse. I hope I have shown you today that information is power and power demands accountability. Access to information is not just a critical component of the right to freedom of expression. It is also a fundamental principle of the rule of law and the backbone of democratic culture. When the regular culture of access to information fails, when routine legal safeguards protecting access to information fails, then we must step forward and protect the individuals that break the walls of silence. Thank you for listening to me today.
Our next speaker is a well-known figure here in Malaysia. He is Dr. Asmi Sharum, who has been teaching in the Faculty of Law, the University of Malaya, since 1990. He currently teaches human rights law, conflict of laws, and international environmental law. He has several publications to his name. He writes columns for local dailies. Let's welcome Dr. Asmi Sharum.
Good morning. I like this headset. It makes me feel like I'm in the Avengers. So I'm going to be talking about freedom of information in Malaysia. Now, freedom of information is part and parcel of freedom of expression. This has been confirmed time and time again when you are exploring and when you are interpreting international laws. For example, the International Covenant on Civil and Political Rights, when looking at freedom of expression, which is in that particular covenant, it's been said many times that this includes the freedom of information. It goes both ways. We express ourselves, that's a right. We get information, that is also a right. Fantastic. That's in the international sphere. What about here at home, in Malaysia? What about us? Well, for one thing, we're not even party to the International Covenant on Civil and Political Rights. In fact, we're not party to most international human rights conventions. We're not even party to the Convention Against Torture. We like torture. But we are party to some. For example, we are party to CEDAW, the Convention for the Rights of Women. We're party to the Convention on the Rights of the Child. We're party to the Convention on the Rights of Persons with Disabilities. And if you take the third one, for example, we see that Article 21 on the Convention on the Rights of Persons with Disabilities, it does say that persons with disabilities have a freedom of expression, which means also receiving information. So if the disabled in our country have this right, surely those who are mainstream also have the right. But let's look at our domestic law, which means that we look at our constitution. Article 10 of our constitution very clearly states that every citizen has a right of expression, speech and expression. I'm very sorry to all our international guests. It says citizens. So you guys have no rights right now, sorry. All right, okay? Every citizen has a right. But it says nothing about freedom of information. There's nothing specific in the Malaysian constitution regarding freedom of information. It talks only about freedom of speech and expression, but it doesn't say anything about information. However, we can always say that it is implied that when you say there's a freedom of expression, it also means there is a right to information. Now, our constitution, with regards to freedoms, there's a lot of provisos. Okay? There are so many limitations in our constitution regarding our freedom of expression. Article 10 says we have the freedom of expression. Hurrah! But Article 10 also says, however, there are limitations to your rights. And depending on how you count it, there are 12 specific situations where laws can be made by Parliament to control and limit our rights. Okay, and if I just very quickly go through some of them, to protect international relations, to protect public order, laws for defamation, morality, parliamentary privileges, contempt of court, citizenship. There could be laws preventing us speaking about citizenship. The special positions of Malays. There can be laws made to prevent us from speaking about special positions of Malays. Now this is not new. Anybody who's Malaysian who has read the Constitution knows this exists. All right, so let's just keep that to the side for now. That's a little bit of background, but it's going to come back and haunt us. All right, let's just hang on to that for a minute. Do we have freedom of information law in Malaysia? Yes and no. We have freedom of information law in Penang, and we have freedom of information law in Selangor. Okay, and these two states have had those laws since 2011. They're not perfect. Yeah, nothing is. All right, they're not perfect, but we do have these laws. We do not, however, have a national freedom of information law. So when we look at these laws, they're called enactments, yeah, because they are state laws meant for the state. And these enactments only apply to the state government. That means to say, if I'm in Penang, which I am often because I am from Penang, which is the best state in the country, it is. All right? When I'm in Penang or when I'm at home, I live in Selangor. The Selangor government, the Penang government, they have an obligation to give me information if I request it. There's, of course, a form to be filled because, nothing in Malaysia works without filling up a form. All right? So there's a form to be filled, etc. But there's a procedure, and you do it, and then you can get this information. There are limitations. There's some information that you cannot get, okay? And I'll very quickly go through them. A lot of them make sense. Of course, I cannot get information which endanger other people's lives. They are under no obligation to give information about which might affect international relations, trade secrets, court proceedings. If it's to protect a third party's copyright, then they won't give you the information. There's a list here. All right, Stephen spoke about these laws briefly just now, and it's good. It's a good step. However, there is one thing which Stephen also mentioned, and this is the huge elephant in our freedom of information in Malaysia. This is a giant, huge bull elephant running around, and we have to deal with him. And it is, of course, the Official Secrets Act. The Official Secrets Act of Malaysia is a fantastic law. It gives so much power to the government to declare anything secret. And when I say anything, I mean anything. All right? And who can declare secret? Any government officer who's appointed, who's duly appointed to say this is secret. Now, of course, an Official Secrets Act is like the kryptonite to freedom of information, right? It is an anathema to freedom of information, and it has to be dealt with. Why is this such a big deal? Well, when we have a law like the Official Secrets Act, a multitude of sins can be hidden because anything can be declared secret. So let me give you an example which is very close to the hearts of Malaysians. In 2016, the final audit report on 1MDB was suddenly declared an official secret. The biggest corruption scandal in the country, in the region, no, in the entire universe. There's a full audit report and it was declared official secret. Now here is what I mean by hiding a multitude of sins. This is important information which the public deserve to know because it's not just about corruption, it's about corruption that affects us, affects our future. We have a right to know this. And no, it was declared official secret. Now, this year, this report has been declassified as a secret because there's a new prime minister, an old new prime minister. All right? And he has declared, look, make this free again. That's all well and good. Thank you very much, sir, but we cannot depend on politicians. This has to be something which is protected by law. We cannot depend on the whims of politicians because they might change at any time. Now, why else? Why are we so concerned about this stuff? Well, to have things secret, like I said, it could hide a multitude of sins. To have information, to get information, is also very, very important. And Casali has given wonderful examples. Amos as well has given wonderful examples. I'm not going to be able to compete. These guys are international. I'm just a local dude. But it's important to us in Malaysia as well. Let's look at something not very controversial, okay? If we are opposing, say, a project, which might affect our immediate environment, we have to have information in order to be able to protest correctly. And when I say protest, I'm not talking about going onto the streets. I'm just talking about using the right channels, okay, which our government officers are so pleased of saying, you must use the right channels. Okay. Now, even if I go into these channels, if I don't have the information, I'm not going to be able to say anything of any worth. All I'm going to be able to say is, look, you're building this and I don't like it. Stop. But I need information. And that is why a freedom of information law is so very, very important, because it means that I have the right to get this information. For example, who is the contractor? How did he get his contract? If I look at the EIA report, okay, fine. Is there any background data to the EIA, incidentally, is the environmental impact assessment. If there was an environmental impact assessment report, is there any background information that I want to back up my research as to whether the EIA was done correctly or not? These are things that I need in order to be able to properly object to something which is affecting my environment. And this has happened many times before. Okay? So this is why we need an FOI. We need a freedom of information law for the whole country. But before we go into that, let me just raise 2 points. First and foremost, even if we have a national freedom of information law, it will be useless if our Official Secrets Act remains there. So something has to be done about the OSA before we can get a proper FOI. Yeah, we cannot go into the FOI with the OSA, this giant mad elephant rampaging around. We have to get rid of the OSA or modify it to such an extent that it cannot be used with such ultimate discretion. That's the first thing. The second point is that I mentioned the Constitution. The Constitution has a list of things where the Parliament can make laws restricting our right of expression. Now, if we take it that our right of expression also means our right to receive information, those very same limitations could be used to restrict what kind of information we can get. And this is something that we have to be aware about because it is constitutionally provided for. Of course, the Constitution says that Parliament may make laws restricting our freedom of expression and, I presume, our freedom to get information. It doesn't say Parliament must make such laws. So for the moment at least, until the Constitution is actually amended, which I'm not sure it will be, we have to put our trust in the new Parliament, in the new government. That's all very well and good, but I've always said that ultimately we have to be self-reliant. And this is why freedom of information is so important. Because look, let's be frank, even if we have the most wonderful freedom of information law in the world, 99.9% of Malaysians won't know it exists. Right? Most people won't know it exists, and I can guarantee you most people won't even be using it. This is the reality. However, for that 1% who are using it, it is important that they are able to do so because the changes that they make with the information that they get can have a very positive effect on all of us, even though the rest of us live in blissful ignorance. Thank you very much.
Ladies and gentlemen, at the end of the talks, there'll be a question and answer session, so you can direct your questions to any of the speakers. That's right at the end. Our next speaker comes all the way from the Czech Republic. She's Ms. Barbara Bukovska. Ms. Bukovska is the Senior Director for Law and Policy for the London-based non-profit group Article 19 since 2009. She leads the development of Article 19 policies and provides legal oversight across the organization. She has extensive experience working on a range of human rights issues, including protection from discrimination, access to justice, deprivation of liberty, reproductive rights, and community development. Please welcome Ms. Barbara Bukowska.
Promoting and protecting legal right to information is a very important topic, but let's admit it's not a very catchy title. My colleagues from campaigns and communications in London struggle with it all the time, especially when they try to make topics like this and talks like this trending on social media. And they also very much hate when they hear that lawyers are involved, because they think that when lawyers they get their hands on any topic, however exciting, however important, we always make it sound very dull and technical. And speaking as a lawyer, I can confirm that when we talk about right to information, we love to talk about international standards on right to information. We love to talk about laws, about court decisions. We also love to invoke the importance of right to information to sustainable development goals, or how important is it for participatory democracy and for state accountability and transparency. So basically, catchy phrases like that. But what do we really mean when we invoke the legal right to information today? What do we mean when we say that information gives power to people to take control over their lives and to hold governments to account? Who owns the right to information? Who should defend it? And should it really be left onto the lawyers and journalists to defend it? So when looking at the answers for these topics, I'm often reminded of a story which Aruna Roy, a famous Indian activist and campaigner for right to information, narrates when she talks about the history of right to information movement in India. And this story involves a very prominent journalist and an activist, a poor woman from a community in Rajasthan who had a very little formal education. And at a press conference demanding the right to information law, this journalist asked the campaigner, this poor woman, with extreme skepticism, asked her how did she think she was qualified to campaign for right to information when many more learned and educated people failed in this quest. And the woman told him, look, if I give 10 rupees to my son and I send him to do shopping for me at the market, when he comes back, I ask him for a receipt. I ask him for an account. Now government spend tons and millions of rupees in my name, so I have every right to ask for an account. Our money, our accounts. And with this brilliant answer, she basically defined the goal of right to information movement in India for years to come. Our money, our accounts. And this became a slogan for right to information movement in the country. I'm also reminded of work of my colleagues at Article 19 in Mexico, who work with indigenous communities in Nuevo Egipto and Lázaro Cárdenas in Chiapas, which is one of the Mexican states. And this community was excluded from proper healthcare for many years because the local government employed incompetent doctors and underqualified doctors who didn't provide a proper care, didn't show up for the shifts, and also didn't keep a proper stock of medical supplies. And with the help of Article 19, over 300 women from those communities filed the right to information requests to local authority, asking what were the contracted shifts for those doctors, what care were they supposed to provide, how much money did the local government spend on healthcare in their community. And then with this information, they demanded the change for medical supplies, and they demanded the proper health care for which the local government contracted the medical facility anyhow was done. So for those of you who might think that what we are talking here today about is very urban or middle-class affair, the story of these women from India and from Chiapas in Mexico shows that women living in poor communities understand how corruption works because they experience it every day in their life. And they also understand the gendered consequences of corruption and how corruption keeps them in unprivileged position in the society. I'm also reminded of work of my colleagues and partners in Russia, where we supported development and running of a special dedicated online portal, Rost-Adviet, which allows individuals to submit the details about information they need in their lives. And these details are then turned with the help of lawyers, so sometimes lawyers are quite useful, into formal right to information requests, which are filed under the Russian right to information law. And this portal now receives about 60 information requests a month. And what originally started as some sort of individual's quest for information about some particular plight in their lives, it's now a very useful tool for journalists and bloggers living in Russia to get inroad to a story about a particular problem in society. It helped them to uncover corruption in 41 regions, social care homes in Russia, and which was not providing adequate social care, or helped them to expose illegal oil refinery working in close to residential area. And this also gave people hope what can be achieved through invoking the law of the land, and also showed that the right information can really outroot the corrupt people through different levels of the government, lock, stock, and barrel. So now we understand that in Malaysia, you are at a very important crossroad, very important part in your history when you are starting processes for transition to democracy. And we believe that experience of Article 19 and many partners around the world can help you to make a case for supporting and developing basis for proper right to information in the country, and that this really can underpin all the reform processes. But in order to make this success, I want to give you some tips based on our experience, sort of things to do and things to avoid when campaigning for this issue in the country. So 3 do's and 3 don'ts. So first is make sure that campaign for right to information connects to all issues. It needs to really start at looking at beneficiaries and end users of this information. What is the information they need? In what form? What for? And also it can help to make sure that this underlying issue for what they need information is brought to the spotlight. And through it also, the right to information can be understood. The second thing is that don't leave the right to information work to lawyers and journalists. Make sure that it involves all the people. And again, it stems from the first point is that when the right to information is presented, not as something theoretical, not as a law, but something really useful which people can see benefiting them, they can really get involved. And they can stop being resigned to state of affairs, succumb to the resignation. And they are not afraid to ask questions and say no about small things which they involve them and their life. And then also big questions later on, such as national security, state budgets, wars and poverty, and so on. And this also involves doing more than just conferences and meetings at the international fora or the events like this. It also involves the grassroots exchanges and people involvements at the lowest level. The third thing, and this was already, I can follow on what the previous speaker said and our Malaysian colleague, is that right to information is not just about the right to information issues. It needs to look at all the other legislation which prevents access to it, state secret laws, defamation, media laws, privacy. And campaign for right to information must include also calls to repel those which prevent and which do not comply with international standards, and making calls for their amendment or for adoption of proper laws that protect freedom of expression. And now, 3 things that you should avoid or not do. And here, the first is that you should not be put off by unpredictable political and legal processes. Because here you are for a really long run. Even in the countries which we heard, like Sri Lanka, which adopted law, it happened after 13 years of fight. So it's gonna take a long time, and many of us have been there. We have experienced that. We have campaigned for right to information law for many years, and then it got stuck in some parliament committee or the government, and years and months which went on to these efforts were totally wasted. Well, actually, the efforts are not always wasted, never wasted, but it feels like that. It feels totally fruitless and frustrating. So what we have done in the situations like this, against such setbacks, is that we used other possible venues for accessing information, such as relying on, health laws, or environmental legislation, such as the examples we heard here already, and try to see whether we can get information through these other venues and processes. And also we worked on laying the foundation for the right to information legislation in the country, looking at the issues such as improving the filing system or archives, working with the archivists, and improving the system which would then enable access to information when the law is adopted. The second thing to avoid is do not get, I know that right to information law, national information law is very important and it's start of all of everything and needs to be the focus, but it's not just about the legislation. It's always about the culture. So the culture needs to change. The best right to information law will not change the culture. The public officials and civil servants are always the biggest enemies against the right to information law because they think that they will be held accountable when it is adopted and that will be somehow responsible. And this is a total nonsense because actually when the law is adopted, it enables them to follow the law of the land. It gives them the foundation under which they can respond, but they don't see it like this. And it's also important to campaign for the information which is not just given, but also information which is meaningful. Because stocks and whole list of raw data will not help anyone to achieve anything. You need information which can be read, which can be reviewed, which can be used by the individuals and those who need it. So it needs to be meaningful. And then the third thing is to avoid is now we are talking a lot about the state information held by the state, but it's very important to keep a focus and avoid just focus on the state, but also look at information held by private companies. And this is especially very important in a situation when a lot of private companies have gained a control over vast trove of data or services and are delivering those public services instead of the government. So we need to also look at the information held by private bodies, by private companies that deliver public function. I very much hope that this experience of Article 19 and all of the other ones who are here, internationals, will help the civil society, activists, lawyers, journalists, and public at large in Malaysia to make the right to information reality here and make it really the genuine forum for dialogue and reforms in the society. And for the governmental officials who are here, I want to leave you with a challenge. In Czech Republic, where I'm from, we have this saying that governmental officials and public servants always talk about the corruption in state administration in the past tense. So just think in 2 years or a couple of years' time what they will be talking about you. And this is much more than aiming for transparency. It is and just exposing the nuts and bolts of what government is doing and making it more visible. We should be really aiming for a new form of government where the citizens and people living in the country can really influence the governmental policies and can shape how and what government is delivering in their name. Thank you.
Ladies and gentlemen, we've come down now to our last speaker. She's from Malaysia, Ms. Cynthia Gabriel.
Can you all hear me? Okay, this is great because I am the 6th speaker, so everyone before me has already said everything. But I'm going to tell you a couple of stuff from maybe a more on-the-ground perspective of the struggle, not just to express, but to be an advocate, an activist that is at the front line of actually talking, trying to get protection, and trying to actually advance the right to information. Now, the very fact that, well, Stephen mentioned this is my first trip to RTM. We have been colleagues and friends for a long time, and now he's in federal power, and I remain in civil society. So it's a very exciting time because it appears that Malaysia is on the agenda of many international institutions and also many foreign governments. Because the very fact that I drove into RTM today, I mean, despite being interviewed by foreign press on many occasions and being used to talk to the media, coming into RTM was very special because it was not a space that was actually provided for alternative, more critical perspectives. So I do want to thank the UNESCO, IPDC, and RTM and very much, of course, the Malaysian people that actually created that monumental change that after May 9th, the slew of reforms that are being discussed via the Pakatan Harapan Manifesto and much more is actually testimony to the fact that the Malaysian people had rejected secrecy, had rejected corruption, and had rejected a style of governance that was unbridled, that was so powerful that it actually did not have sufficient checks and balance. And so this is why I think it's so critical that we are discussing freedom of information. The right to information is the best check and balance where the public, the people, civil society, investigative journalists, academic institutions, law professors, etc., can actually hold the government to account. Now, we have heard so much about accountability in governance. But I wanted to tell you an example, give you a few examples so that we can actually connect why it's so important for Malaysia to use this moment. Because 1 year down the road, it could be a very different environment where maybe more things would be closed. RTM could belong to a new set of shareholders that belong to the current government. Now, we hope that will not happen because this is also the national mouthpiece of the country and it needs to report on many things that are going on. But media ownership is one of the very important things that can determine the right to freedom of information. Now, my second point is about the link between human rights and corruption. In this country, I think we have never seen it so obvious in the case of the 1MDB, when it was a mega corruption scandal, in fact, the largest financial scandal in the world today, that is still being investigated by 6 different jurisdictions, and it's mind-boggling if you actually follow the financial flows. At that time, I will never forget, I will really never forget, that the culture of fear, which I think really needs to be expressed here, the culture of fear was something that was so gripping, because even if you wanted to ask something in the media, or you mentioned the particular name of a person in power at that time, it became so contentious because you would be hauled up by the police for just asking for explanations. Now, we're not even talking about whistleblowing, but we are talking about trying to get clarifications on various things because the Department of Justice was already filing civil forfeiture suits and so on and so forth. And then a public protest. A public protest is also a right under Article 10 of the Federal Constitution. You have the civil society leader that organized the protest detained under security laws of the country. Now, that was the kind of culture of fear that we faced. So I am very excited that in this last couple of months, we have been discussing real reforms. We have been discussing what Pakatan should be holding on to in the manifesto, but we've also been hearing the fact that, yeah, don't look at the manifesto as a Bible, it's just a guide and so on. So which is why I'm saying that it is very, very essential that this next 6 months or 12 months, we must all put our heads together to assist in actually changing that culture of fear. That now we can speak freely, we can have different perspectives, and we can actually celebrate that right to diversity, the right to different perspectives, and so on and so forth. So when I was a city councillor in Petaling Jaya, at that time, I'm not a political party member, but I was appointed as a civil society activist. It opened up my eyes to many things that were actually happening in governance that appeared to be extremely entrenched. It wasn't just about one civil servant taking bribes or one civil servant actually trying to manipulate the system. It was systemic. The whole procurement system, for example. I sat in the tender board. There was one meeting that actually took place, and it appeared that the same person was applying for the project under different names, under different companies, and so on. And it was also possible because the tenders were not completely open on everything, and the only thing that was announced was who would actually get the tender at the end of the process and so on. So the issue of procurement, that it was not all open tender, many were negotiated tenders, and it did not have that transparency component to actually help the public know which contractor actually got the job and so on, became a very big issue. It became such an eye-opener to actually realize that we actually needed to open up the system. And then there was another issue of a public highway that was being built in Petaling Jaya. Basically, it was going to remove about 60,000 homes, very old established homes, because it was an elevated highway that was supposed to mitigate traffic in Petaling Jaya. But when some of the residents actually applied in Selangor for information at that time on this highway called the KEDAX Highway, what actually transpired was the reply, even though Selangor had a Freedom of Information enactment, it was actually bound by the Official Secrets Act. So the Official Secrets Act superseded the state-level Freedom of Information enactment, and the reply that the residents got was that, sorry, we can't give you the information because it is a classified secret. And so the residents got very angry, they started protesting, and there was a change in the Menteri Besar at that time as well. So it became very political. And the new Menteri Besar then decided, okay, we'll scrap it, it's just too much controversy, and so on and so forth. But the questions that were asked is what I was going to pinpoint. It was very basic questions. How was the tender awarded? Was there open tender? Why did the highway cost 14 billion ringgit for a 13-kilometer highway? And so what is the justification of the cost? And there was issues of the developer that was given the project actually linked to a former judge and his spouse who was actually running the company and so on. So then this issue of political patronage, corruption, this issue of looking at ending crony politics is a very, very essential part of the reforms that need to take place. And in all of this, the heart and the center of everything that needs to probably change structurally and culturally is the right to information. And I want to go back to the fact that it is really the public, the Malaysian people, that needs to be empowered with this information. So I can understand the government actually saying that some things need to be kept secret. But they must define, as Stephen said, it must be very, very clear, what are you keeping away? Now, despite the promises in the Pakatan Manifesto, we still have massive disappointments when we get news announcements. Like, for example, the Council of Eminent Persons that was formed a few days after the Pakatan Harapan government came into power. When they came in, they were actually formed to advise the government on many issues, especially on economic issues, which were very complicated because it involved race, policies, and all kinds of different changes that needed to take place. So at the end of the 100 days, what actually transpired was that the report was then told that it was going to be secret, and it was not going to be available for people to actually know. So then it's like, hey, come on, you're a new government, and you actually have to show that you're more willing to share information. So I take that some things might be very sensitive in the report, also because the 1MDB investigation committee, of which I'm a member of that committee as well, is an investigative committee, and the investigations are still going on. And so, as a result, it might not be so feasible to share everything. But there could be willingness to partially share a lot of the reform proposals, for example. The reform committee that was part of the Eminent Persons Council is actually ready to share information, and it's up to the government now to decide what is actually able to be shared immediately, and they cannot delay. And this is the point. They cannot actually delay on trying to show that they are going to be different from the others. Now, there are many other interesting reforms in Parliament. For example, select committees being formed where parliamentarians can actually have more opportunities to discuss, because we've had problems with access to information by MPs, where bills as thick as this will actually arrive on the desk of parliamentarians 24 hours or 48 hours before they have to start debating the bill for the first reading and so on. So this entire thing must change, because there needs to be bigger debate, there needs to be bigger access for public to also get on board to discuss law reform, to discuss public policy shaping, and very much to discuss the kind of priorities that needs to take place within the first year, within the second year, within 5 years, etc. So it doesn't just become like a government burden, but it also becomes very much a participatory type of government that will allow access to information, that will allow scrutiny, and that will allow better accountability. Now, before I end, I just wanted to touch on the challenges forward. Many people, many of the previous speakers have spoken about the Official Secrets Act. That's the bad guy, the boo-boo, the roaming elephant, as Azmi said. But we also understand that in the manifesto, we're just talking about review. Now, the question is, should we actually advocate for a repeal of the OSA? Or is a review necessary? Now, we know in the case of India, both laws actually coexist, and whether that is a possibility for Malaysia. But that would be something that I hope we will be able to discuss a little bit more. In terms of whistleblower protection, I can vouch firsthand, we've heard many examples, that as a whistleblower myself, I think this is the kind of protection that really needs to be given immediately. Because people who blow the whistle on corruption, on human rights abuses, actually get harassed, arrested, charged, and we've seen so many civil society representatives actually being hauled up to the police station, being investigated for the Sedition Act, for the various types of laws that are in place, and including investigative journalists. Basically, there's no investigative journalism in Malaysia. I dare say that. I have 1 more minute left, and I think the reforms that need to be spoken about is how to actually create a more investigative culture. We all have our mobile phones, video, and all that. We actually have to start looking out for how we can keep our governments in account, how we can use technology to actually create a more transparent, more accountable government, both at local government, state, as well as federal. So this push now for freedom of information law in Malaysia is one that will require political will. It is one that will require the erasing of the culture of fear among Malaysians, and that must actually mean that more Malaysians must be willing to speak up, more Malaysians must be willing to ask for information, even though we don't have a law yet at the federal level. We need the governments to be more open in trying to share information through open data methods and so on, not just about things like traffic and ways and all that, but more sensitive information that we must believe that the public, the Malaysian people are mature enough to be able to argue, debate, and everything that will actually assist the government to be one that is better than the previous one. Thank you.
Like I mentioned earlier, we're going to have a question and answer session. We're going to set the stage. Meanwhile, once again, for those who would like to share this event, you can hashtag at IDUAI, or access to info, or right to know, or IPDC Talks at KL. Yes, friends, ladies and gentlemen, if information is power, then access to information is definitely empowerment. It is a universal right, it's our birthright. We're going to get all the speakers up on stage in a short while, and well, we're going to limit 2 questions per speaker, okay, and please direct them to any particular speaker that you want to answer your question.
Hello, good afternoon. My name is Amy. I'm from the University of Asia Pacific University. I'm doing IR. International Relations. I'm in my 2nd year. I would like to ask a question to all of you. What is the safest way and most effective way to raise awareness in the civil society to countries, to democratic countries?
Well, usually the civil society players would be aware. Yeah, those who are actually in NGOs, etc., they would be aware because it's so important to their work. So that if there's any development in legislation, they will know about it, they'll be aware of it. And more often than not, I mean, the legislature, parliament may actually invite people to give their points of view with the law, etc. I think what you're talking about perhaps is the public in general. Yeah, that's a bit trickier because that requires, in my point of view, that requires a much more, a broader kind of output. And that kind of scale normally would require something like RTM, but it used to be easier when RTM was the only channel we had.
Are you asking about Malaysia or general?
General, in democratic countries in general.
Well, I think I'll answer for Malaysia first, because the challenges now for civil society to not just promote FOI, or right to information, but also to be important checks and balances for the new Malaysia now is one that is very important to be strong, because I'm not sure how long you've lived in Malaysia, but to know that I might be going a little bit further than what you're asking, but the colleagues who are now in federal power, our new government, were very much champions of many things that civil society were also talking about, discussing, championing, advocating. So in this new environment, I think it isn't just anymore civil society demanding and advocating, but the federal government also living out many of the commitments. So for example, the Ministry of Information and Communications that gave an opening speech just now must readily allow communication channels for public, civil society to actually appear on talks like this to help promote awareness on various things. So it is an environment that can be maximized, a lot of opportunity for civil society to become more mainstream in departing information, disseminating information, actually getting the public to be more aware of their right to know. Because the earlier point of Azmi that you can have a good law, but if it's not utilized, then it's just on the shelf. So that can be assisted by new forms of communication. There should not be controls in the media. So for example, billboard advertisements, TV commercials should all start talking about rights. And why not have a right to information advertisement in between the news, when there's a break for news. So there's many things that actually can be done, that civil society can actually cooperate, provide content, provide input, and so on. So
yeah,
I don't know whether that is actually what you're asking, but I'm just trying to explain a scenario that is possible.
Yeah, I think I'll just chip in a little bit with the South Asian experience, because the question that you asked is interesting. You see, in India, for example, and I think I mentioned this in my presentation, the people, you see, got involved in RTI because the RTI activists or campaigners lived in the villages, yeah? They were not really based in Delhi or in the big cities. They lived, for example, in Rajasthan, in villages, and worked with the people around RTI. Aruna Roy is a very good example. Now, that's a singular example. India has a very particular, very powerful RTI sort of process in that sense. We can't all emulate that. I don't think it's feasible in that sense. Sri Lanka's example was, as I said, also was a little bit different because it was more a group of lawyers and journalists and activists and people getting together and making sure a good law comes out. But there, what we found is that if the law is implemented independently and properly, you don't need to teach people about RTI. You see, ordinary people living in villages or wherever, as the case may be, are already fully cognizant of the injustices that they come across. So when they see a law being worked properly, not only a law in theory, but it being worked properly, they will make use of it. And in Sri Lanka, up to now, the majority of applicants and appellants before the commission are ordinary people. To my greatest, sort of joy, they are not journalists or lawyers or, civil society in Colombo. They are actually ordinary people who use the law in Sinhala and Tamil and come and argue their case before the commission. And that is extraordinary. So the implementation of the law, if it's done properly, I think is a major issue to really take the law to the people.
Let me also say something from the perspective of being in government now, but of course, I was colleague with Cynthia and people in the civil society. I think, firstly, of course, Ellie, please have a seat.
Thank you.
I think first, very importantly, all of us talk about secrecy, not just from the perspective of laws such as the Official Secrets Act, but it's also a culture of, and this culture is embraced not only by the civil servants, but also by the society in general. So, first and foremost, I would like to encourage, or rather to tell you that don't get used to your government saying this is not your business to know. Do not ever get used to that. Because even if we have laws such as the FOI, the Freedom of Information legislation, what happened is that when we are not used to working with information or access to information, then you have a scenario like what was happening in Penang from January 2015 to June of 2016, a period of about a year or plus. The highest request for information, with this excellent tool available, the highest request of information was really for, Azmi would be familiar, Sijil Farai, Islamic Inheritance Certificates, which is, I think, should be available even without this, without appeal to freedom of information enactment. But what is happening is that we are not used to demanding accountability from our government. I think that is something that the people in general, especially Malaysians, should bear in mind post May 9 even.
So your question was about the democratic countries and civil society in democratic countries. I don't know which are these countries, but if we are talking about the countries in the West, let's say US or United Kingdom, I have to say that a lot of public and also civil society has been brainwashed by this propaganda that some information needs to be kept secret because it's important to keep people safe. And that's also was raised here earlier as a starting point for the governmental official was, is there a genuine reason for keeping certain information safe? Is it important to keep what is happening at a governmental meeting? Is it needed to be secret because there are genuine interests? And this is very difficult to challenge, but because people really believe in this propaganda, and they need to be constantly reminded that actually information which the state holds, they hold this information because people put them in a position to have it, and they hold it for the people. And the definition of what is necessary to keep safe is very broad and shouldn't be so. And this goes even to information about which was, let's say, put on WikiLeaks about the governmental cables or about Snowden revelations about the spying. So these are very important issues which show a huge violation of human rights and should have never been secret. So the challenge is to get them excited and campaigning for all the information to be transparent and this exception to be very narrow and not in a way which governments understands them, but which are in public interest.
Thank you. The question has been answered. You happy with the answer? Okay. I think the gentleman over here, gentleman over there. Okay, go ahead, please.
Thank you for a very wonderful Careless University. Yeah, it seems my question has been partially answered by Mrs. Barbour, but I will still ask the question. Okay, now, how do we overcome the challenges in trying to determine or differentiate or draw the line between what is official, what is classified, and what shouldn't be classified? How do you overcome that challenges, the blurring line between classified and non-classified information? Because the government will say, yeah, it's classified, so we cannot talk about it. So that's my concern. Thank you very much.
Well, as far as I can tell you, as far as government is concerned, their interest is always classified as much as possible. So one of the overcoming ways is to protection of whistleblower and encouraging whistleblower and also supporting the platforms through which people who are inside the administration and who are aware of those gross human rights violations can make this allegedly classified but important information in public interest available to the public. So it needs to go hand in hand with protection of whistleblowers and so.
Anyone else wants to share?
Sure. I think that the starting point from the perspective of Article 19 of the Universal Declaration as well as the International Covenant on Civil and Political Rights is that, the classification of information is a restriction on the right to receive information, which is a component of freedom of expression, right? And restrictions can only be subject, must meet like a tripartite criteria. It has to be provided by law, and not just any law. There must be some form of democratic process behind the law. It must be necessary and proportionate to meet a specified legitimate objective, right? So it can't just be a very broad assertion of national security. There must be a very detailed justification that the government provides on the basis of national security why certain information should be classified. And I think the prevailing kind of spirit is that, exceptions must be extremely narrow and that the default, as Barbara was mentioning, should be declassified information.
The important thing is that there has to be a higher aspiration for freedom. That should be the guiding principle, that freedom is a good thing, and anything which limits freedom is a bad thing. And if it has to be there, it has to be very, very minute. Also, we can't deny, if you're lucky enough to have a decent court system, and if you're even luckier to have intelligent judges, we cannot deny the role of the judiciary. Because the judiciary could be a check and balance as well, where they could declare that, for example, a particular law or particular action on the part of the government is unconstitutional and disproportionate, like the principle that you mentioned.
I would add comments to that. You see, one device, and I think this may be important for Malaysia as well, one device that we employed in drafting Sri Lanka's law was that to provide that Sri Lanka's RTI law prevails over every other enacted law as at that point. So no law. Now Sri Lanka has a similar Official Secrets Act. We've all got these colonial era laws, in our statute books, right? Colonial legacy that has really not left us. But Sri Lanka's law provides that all these laws, we don't have to mention the Official Secrets Act specifically. There was an argument whether we should emphasize that. We said don't, because we don't have to privilege that. Every law prior to the RTI Act of 2016 is lower in status. And the information law is higher in status, right? And there's the second device that we employed, and that is common in India as well, in other countries as well, is that right to information is subject, yes, to exceptions. Sri Lanka has the exceptions, 14 exemptions, including national security, but there's a public interest override. So the public interest override prevails across all the exceptions. And that is the predominant criterion that one has to use. But there again, and I would advise this also as a caution, reliance on the courts entirely is problematic in our region. The commission, the independence of the commission that is appointed to examine issues under RTI must be independent, and it must be independently nominated and appointed and not solely left to government. That, I think, is a very important fact. In Sri Lanka, the commission is independent. I would never have accepted appointment. It was solely a government process. It is an independent nomination from the Bar Council, from media groups, from editors, from civil society organizations. And the commission coming into place is not subjected to any political pressure whatsoever. So those are some cautions that I think Sri Lanka could offer to Malaysians in the process.
Okay, thank you, Doctor, for that question. Gentleman over there.
Yes. It's in the statute books, but it doesn't. It's not.
Good
it's
afternoon.
irrelevant.
My name is Suresh from Asia Pacific University. Now, I deal with a lot of young people, and I want to know, this question stems from what Dr. Azmi Sharum said. He says, only 1% are interested and 99% are not. Now, my question is, how do we change young people's mindset? What can you do to make this topic an interest for the young people? What can we do? Because the numbers are too small. I'm more concerned about how to get young people to be excited and say, I want that information. Because we want to grow the civil society, we want more people to ask questions, but what can we do? In the universities, we try to do a lot of things, being a private university. There are a lot of restrictions, okay? And I want to know whether the government, the new government of the day, are going to help us to bring about the new culture, new mindset among young people. But what can we do? What can you do? Civil society, law, government. Can you please advise? Thank you.
I think, to put this in perspective, what Azmi has said about only 1% will probably use the FOI instrument if it was ever enacted. Japan has very low crime rate, but the police stations are still there. I think the whole idea is really to push for institutionalizations of democratic elements, for example, freedom in the various elements, including freedom of information. So I don't think the widespread of interest in using certain democratic institution has anything to do with whether we should or should not promote it. But again, the question goes back to how do we spark off interest in the civil society? How does the government, or rather this administration, plays our role to spread this sort of awareness? I think in that aspect, the university, of course, Suresh yourself, play a very important role, spreading the campaign awareness to students. As we can see, the government through Saudara Gobin's ministry has opened up RTM, the national TV, to be part of the platform to use to spread this sort of awareness. And myself, I've met with C4, I think at least twice in the last 2 months of my appointment, and Cynthia is already planning a third meeting with us. So I think the engagement is there, at least with this new administration, but I think this is a joint effort. The government is willing to open up our platforms, including the national media channel, but civil society and individuals have to play our role to also step forward and be part of this process of change. And I like what Cynthia said, keep us accountable, not just in the sense of looking from afar or voting every 5 years, but also to ensure that promises in the manifesto are met, at least in the next 3 to 6 months.
If I can say something, I think that you don't need to worry actually about young people. I think you have to be worried more about old people, how you understand it. Because I think that young people are quite aware and quite follow on this issue. And I was actually watching my little nieces a few weeks back, and they are from from 5 to 9, and they were playing with some whistles. And I asked them, are you training to be referees? And they said, no, we are training how to be whistleblowers. So I don't think at age of 5 I even understood what whistleblower was. But, so they are pretty aware. So let's focus on the governments when we want to campaign on this issue, and those in general public, regardless of the age.
Just a very short reality call from Sri Lanka. You may be surprised as to who will use this, because in Sri Lanka, the government also thought the same thing. They said only 1% will use this. That is why the law was enacted with all what we wanted in that, because they thought the people won't use it. And they've been surprised out of recognition because of the way it's been used. So I really think that we have to wait until the law is enacted to see actually who will use it.
Cynthia?
The scenario was such that the past 60 years is something to do with our education system, really. And it was about don't ask things that are political. Don't ask things that will get you into trouble. Don't ask things that matter. I mean, if you wanted to start an orchid society or something less threatening, they would probably support you for something like that. But if you started to ask questions about your neighborhood environment, public policy on something, or even about why your teachers are like that, you cannot ask. So it is just part of that culture that I was referring to and many of us were talking about. You have to create an environment, and I'm telling Stephen actually, that a big part of it is with the government creating an enabling environment that will make youth participation interesting in wanting to be part of the reforms. So, I mean, there's many things technology can assist in actually making it exciting. So instead of going on Facebook to chat with friends, you can also use Facebook to keep the government accountable through apps like we created before. But that one had limited space because there was a bigger federal power that was controlling everything, including Facebook comments, which they said they wouldn't, but then they did. And people were hauled up for criticizing all kinds of things. So that has to change. People need to actually speak freely and ask freely. And so I think there's a big gap to connect with what the youth are interested in and the issue of reforms. But it can be very easily managed with creative ideas. And I think that culture of change can only come with political will from the new government.
I don't know, man. I mean, you know, young people, anything that these guys do, no matter how young Stephen is, right? He is very young, but even though they're going to be uncool. I'm sorry. I mean, like, there's nothing anyone over the age of 25 can do to them which is cool. I deal with young people all the time, and I feel ancient and horrible, and they don't look at me anyway. They're looking at their phones. But having said that, which is a terrible thing to say being a lecturer, I think the media has a very important role to play, because it's the media which can put forward stories, like, you know, the stories that you guys are telling, right? These stories are important that people, and then people know, all right, okay. And then they'll come to their own conclusions. You know, I agree with Barbara, we shouldn't worry about the young, they'll figure it out themselves. And if we try too hard, we're just going to look uncool.
Okay, thank you. We have time for two more questions. The lady over there, please.
One more
Perhaps
comment.
the media should focus more on who is bribing who rather than who is baiting who.
Okay, the lady over there.
Good morning. Thank you very much. My name is Dr. Marceline Girol. I'm French. Sorry, we speak today. I live in Malaysia for the past 10 years, and I followed the last election very closely because I cannot vote, I cannot move. My embassy has said that I cannot be involved, and I was very happy to do so because I saw a lot of good things. In fact, I find out that the Malaysian election was done, in fact, more on internet and social media than really on the normal media platform. And this was a shift. I saw the youth moving, and especially towards the new government, and mobilizing. And in fact, this was also very new to me, that such a big movement can come from the youth side. They were more aware about their rights and what should be Malaysia, the new Malaysia, and their hope. And my question is, as social media was so impactful in the last election and brought you the awareness that you have, and we entered the fourth industrial revolution, where we don't speak anymore about tools, but about people centered in the technology. What is your take in terms of information, in terms of communication, and in terms of usage of the fourth industrial revolution to make the invisible visible and to change the movement for the next generation?
I have a moderator suggestion, which is why don't you take a couple more questions and then, so in the interest of time, and you can wrap it up.
Yeah, the question over there?
Hi, I'm Brian Larish from the Make It Right movement of Brickfield Asia College. I'm actually to YB Stephen. I'm curious to what extent does information be shared between your ministries? As an activist that deals with children, for example, stateless children in Sabah, I deal with the Ministry of Education, but it crosses to the Ministry of Home Affairs, and we always get the same reaction, right? We have to speak to somebody else, we'll get back to you, and nothing is shared. So that loophole is always there for those of us who want to do work on the ground. So what effort is being made by the government now, and to what extent does your cabinet meetings actually share all this information with each other? I mean, for us it's quite difficult. We can't move forward when one ministry says go speak to another, and then that ministry never gets back to you, especially to give you an email that no one answers. Yeah, so I'm curious to know what effort is being made with that.
Okay, the last one over there, and then we'll give it to the panel to answer.
Thank you, Chako Vadaketh. And my question, perhaps to the Deputy Minister, since the Deputy Minister for Communication and Multimedia is not there, and perhaps to Cynthia as well, from the civil society perspective. An area that I think there's wonderful opening up of access to information, especially in the new government, but an area that is still shrouded in secrecy is the royal family and 9 heads of state. And in particular, the incident where Kadai Jasin wrote about the Yang di-Pertuan Agong having had to be paid, or the country having to spend 157 million on its upkeep for 16 months, and the Treasury saying, oh, we allocate 13.5 million per annum for his upkeep, and he had to step down. And nothing further seems to have been said about that, and Anwar Ibrahim was very upset that such questions are being asked. But surely there should be access to information on how much we're spending on our royal heads of state, and also their dealings in business. If they deal in business, that seems to be shrouded in secrecy as well. Are we going to have access to information on that? Thank you.
Thank you, Chako.
Thank you. My name is Ramachandran from Taylor's University. My question may be posted to Azmi. See, when we teach media law, the first thing we ever introduce is Article 10. But in the same voice, in the same hand, I also hold Article 19. My question is, Azmi rightly pointed out that while Article 10 says we are free, in the same breath, there are 12 other laws relating to restrictions. Like Chako said, don't ask questions about the royals. Now my question is, why hasn't Article 10 thus far been able to make a dent in our laws?
Okay, over to our panel.
No, this guy's been raising his hand like it hurts.
Yeah. Good afternoon. Thank you very much. My name is Wan Kasim from the Office of the UN Resident Coordinator for Malaysia. So a lot of the discussion on freedom of information was made in the context of human rights, and rightly so. Right to information is a fundamental human rights and should be enjoyed by every human being. We welcome very much the commitment of the new government to give greater priority to human rights. Even so, in this light, there is this argument that human rights should be tailored to domestic values and domestic particularities, as opposed to the internationally recognized standard of the universality of human rights. So, what is your take, perhaps, Dr. Azmi Sharoom, perhaps YB Stephen and Ms. Cynthia? What is your take on the potential impact such a interpretation or thinking, conception of human rights can have on access to information in Malaysia? Thank you.
Dr. Azmi,
okay, very quickly, Ramachandran, the question is, the answer is because Article 10 actually shoots itself in the foot. We have Article 10(1), which says every citizen has a freedom of expression and speech. But then Article 10(2) says Article 10(1) can be restricted in these circumstances. Okay, that's bad enough. What's worse is that, generally speaking, our courts are reluctant to actually limit the limitations on our laws, on our freedoms. Because if you are allowed to make a law restricting our freedom of expression or freedom of information based on the concept of national security, but you don't define what national security is, and you give it this broad idea of anything could be national security, then our freedom is illusory. And in that situation, it is up to the court to say, look, you can't do this. You can't just use the term national security to make any law that you want, which in effect makes our freedom absolutely false. right? So the problem is twofold. One is that because the Constitution itself it gives too much leeway to the government to make laws to restrict us. Our courts do not actually defend us hard enough because they're not willing to make that argument which forces the government to behave in a way which is reasonable. Our Constitution also does not have a preamble, which means we do not have any sort of higher aspiration to what kind of ideals we want as a nation. So this is the problems we have constitutionally. Very quickly to the last question, universality. That is, what's the term? Cultural relativism. That is used by dictators all over the world, particularly in Asia. Lee Kuan Yew did it, Mahathir Mohamad did it, he seems to be doing it again. All right, we are different somehow. Okay, fine. I guess Asian people don't like freedom of expression. Asian people like corruption. Asian people don't like to have freedom of religion, freedom of speech, all this kind of stuff because we're Asian. It is an argument used by despots and it must never ever be accepted.
So, I mean, just jumping off those comments, I just want to address at a very high level, like this interplay between domestic law and international law. I think at this critical political moment, it is incumbent on the Malaysian government to seriously consider signing and ratifying the International Covenant on Civil and Political Rights, as well as the International Covenant on Economic, Social and Cultural Rights, right? Because this argument from Asian values that somehow civil and political rights deserve less priority in this region really doesn't hold any water because of the independence between all human rights. In order to solve issues relating to economic inequality and poverty, information is power. Information, is required to help solve those kinds of problems on the ground, right? So this is the kind of deep connection between access to information and what we call economic or social issues, which are actually matters of human rights. So as to the question about social media and the role of social media, I think there are several tensions that are important to raise. One of which is, yes, it is true that social media has really changed the way we think and talk about elections as well as other political activities. And some people have argued for, greater responsibility on the part of companies to actually police the platform or in the alternative, to allow it to be truly a genuine platform for expression. And, I think the platform, social media platform is really, like just any other platform. Freedom of expression principles govern. They should be the touchstone of any kind of regulation, whether state or private. And we want to also seriously think about the dominance of these platforms, right? When a single platform, in people's minds can make or break elections, we really want to think about what that means for democratic culture, whether we actually want to have that kind of platform dominance exist, and whether we must look to other forms of regulation, for example, in competition law or data protection law, to kind of rein the power and influence of these platforms.
Right, tough question, but I started my presentation just now with the true story of my copy of Serat Centini. Check it out, Kama Sutra of the Javanese world. The fact is, it was 12 volumes, but when it was republished here in Malaysia in Bahasa Melayu, it was reduced to a very thin 1-volume edition. I think without going to engage that philosophical argument about universality versus cultural particularism. And I didn't say this because I'm in government now. Read my book, Being Malaysia, which was published just before the campaign. I think it is also not fair for us not to take into consideration certain sensitivity because of, say, religious values, cultural or traditional worldviews or perspective of a community when it comes to governance, when it comes to legislations and rule of law. It is very easy, of course, and popular to say, everything's universal. Everyone have the same idea of freedom. Everyone have the same idea when we talk about human rights. Everyone have the same idea when we talk about freedom of information for that matter. But what I think is important at this point is, going into the question by Dr. Marceline from France. I think whether social media or traditional media, whether Industry Revolution 4.0 or not, the problem, the challenge that we have in Malaysia right now is really very fundamental in terms of how government agency is being connected, sharing of information, management of information. I mean, even if we have a FOI legislation today, I would imagine if you fill up a form to request for something as simple as Penang export and import activities, it will probably take you, 2 months. So very fundamental, how do we manage information? This is technical, of course. But on the other hand, we are also not just talking about FOI or OSA. I've raised in Parliament before about the Statistics Act. No one cares about the Statistics Act, but it is like 50 years old today, now, by this time. So how government collect information, how government corroborate information, how government publishes information, all these have to be dealt with. And I think the monarchy being an institution, an important institution, this is where I go into that sensitive area, being an important institution has to realize that if this is the direction the country is taking, then they have to follow suit in terms of transparency, in terms of freedom of information, in terms of human rights. And all this is not just government domain. Again, agreement to certain values in our society, certain values in government, has to come from the people themselves. Did we vote for the censorship of Serat Centeni, the Javanese Kama Sutra? I don't know. Maybe half of the population did, and would agree to that because I was told that it was pornography. Did we vote for certain actions of the government now and then? I don't know. Maybe part of the population did. So I think there must be some kind of national conversation, consensus about values that we cherish in our society as Malaysians. And this is the process of consultation, of course, moving towards reforming our institution as a whole.
Okay, thank you very much, Stephen. I'm afraid, ladies and gentlemen, that's all the time we have for you. We'd like to once again thank all our speakers.
Yeah, we want to say
you want to say something?
Yeah, I think it's the question on social media is a very important one because that's the space. Even in the more hostile times, that was the space that was available. And we know that Malaysia wasn't the only country. There were other countries that used social media to attract public attention on what was going on. So one of the things we did, just to share two things, very important in social media, we actually launched a website called Kleptocrazy, which was out to get the public to report on people who were living with suspicious wealth. And that was motivated by the 1MDB scandal, of course. So we could not get institutions here to investigate. That was the level of how repressed the things were at that time, that even the MACC could not investigate properly, neither could the PDRM and so on. So what actually got us motivated was, okay, maybe you can launch something online to see how much interest can be generated. But it was difficult because it was one thing to launch an app on local government, service delivery and all, which got a lot more feedback. But it was quite a challenge to actually get people to lodge complaints on politicians and powerful people living with suspicious wealth or living beyond their means, because we don't have an asset declaration law here, which is another reform that is taking place. And the asset declarations have to be public so that the public can scrutinize politicians and have them come in with integrity. Those that are corrupt have no place in society and so on. So despite the difficulty in getting information and all, we got some people posting images of the former regime and some of their politicians that somehow, some of them got voted back in, some of them were rejected. It was very interesting to see the number of cars they had, how many houses they actually had, and things like that, and how many companies they were shareholders of, and so on. Some things are available because public listed companies have to declare anyway who are the shareholders and stuff. Some will actually require a bit of snoop work, that you're actually following someone because they're driving a Lamborghini, when actually they are someone in the civil service who cannot afford that kind of luxury lifestyle. So it was a very interesting exercise. And then I think the most famous, or the board game of the general elections was something you might have heard of. It's called the Kleptopoly. We created a board game. It was so difficult to get the Malaysian people to check on financial flows of the 1MDB. Unless you're in the industry and really researching and studying, it's so easy to get lost, because money was not just stolen from one person and given to another. It was a maze of different things. So what we did was, when the Department of Justice came up with the first civil forfeiture suit, we actually used the information there. I mean, it was formal DOJ information, and we put it, inspired by Monopoly, so we put it on a board, all the stolen 1MDB property. And it's like playing Monopoly. But the moral of the story is, you get rich, but you must get rich only if you're clean. And that's how you can win the game. And it taught a lot of young people about fighting corruption and stuff. And we had Bloomberg, AFP, and all that cover the news for us, and Malaysia Kini, of course. And it just helped get a lot of things going. So I think my point, I'm sure my point is, the challenge to civil society is really also, and to the new government, is also about being creative, trying to find different ways, thinking out of the box. And I mean, we've got an excellent Azmi Sharum, always thinking out of the box. So more academics also need to start coming out and finding ways to connect with young people and so on. And I think I just wanted to touch on that question of the royalty and the excesses. It's a no taboo topic still. But it was very disappointing that Kadir Jassin was lambasted for exposing something that may have needed further investigation. And so the point here is, how do we actually enhance investigative journalism? Which means the environment that needs to be created, that they can report. They can actually go dig deeper, report without getting into trouble. The Malaysian Insider was shut down because they were trying to report things. Now, it might not be entirely true, but the Malaysian Insider exposed something. So you investigate, and if they were found to be malicious or whatever, you have other laws that can take action on them. But if they were whistleblowers that were showing something that was important for the Malaysian public to know, then I'm suggesting to the new regime, and I hope Stephen doesn't feel so pressured, because he's one of the great guys in the new government, that's the culture that needs to be enhanced, that you need to give that space for journalists to actually investigate, even if it's really a taboo subject about the royalty or whatever it is, Malay rights, and so on. So that's not going to change in 4 months or 6 months. That's going to take a lot of will to have a different Malaysia. And I think really it's each and every one of us that will have to play our parts to make that happen. So we need to keep pushing the government, we need to keep negotiating with them, proposing reforms, checking them, and having better access to more transparent public policy shaping and all that.
Okay, quick remark from Kishala and Barbara.
Three concluding comments to apply some of the matters we discussed here into the RTI struggle. In Malaysia's process on RTI, I would just like to give 3 lessons from Sri Lanka. One is that perceive the public servant as your colleague rather than an enemy of RTI, or rather the target of RTI. Now, in Sri Lanka's law, it was because a lot of public servants felt very apprehensive when the law was enacted. I think, Stephen, this came out a little bit in your comments as well. And the government does feel apprehensive, because any government who enacts a RTI law is doing so against itself. Let's be honest about it. In England, the British FOI law, Tony Blair many years later said that he was the biggest idiot in the world to have enacted the RTI law, the access to information law in the UK. And every government is going to feel that. In our case, what we did was we tried and crafted the RTI law to actually protect honest and good public servants, and not to make the entire public service feel that they're being targeted by the RTI law. That's one. Second issue is, when drafting, don't settle for compromises that are unacceptable. In our case, unlike India and other countries in Asia, which shut out certain intelligence agencies from RTI, Sri Lanka's law applies across the board to all defense ministry, intelligence apparatus, all the most sensitive areas of government. And the issue was that no entity should be privileged. The privilege should come not in terms of entity, but in terms of the information asked for. So if information asked for trespasses on national security, then you weigh the balance and you give information, or you don't, as the case may be. The third point that I would like to really emphasize is that seize the opportunity now, because given Sri Lanka's process, which is very similar to Malaysia from what I can see, if we had tried to enact the RTI law of 2016 now, it would have been impossible. So much has changed during the last 2.5 to 3 years. So I think Malaysians should seize the opportunity now and enact the law as quickly as it can, because if the mood changes, there will be real problems ahead in the future. Thank you.
Okay, one last remark from Barbara.
And also, two concluding points from me about the universality and about the need to be sensitive to local cultures and sensitivities. I'm not Malaysian, so I don't know what values you hold dear, as you said. But in my experience, my government also tells me when they violate human rights that they are respecting my sensitivities or my culture. And it's usually just the culture which governmental officials or certain groups in society hold dear, not the whole public. So as an individual and citizens, then we can say that actually this is not a culture worth of respecting. If the culture violates rights of women or minorities, it is excuse for human rights violation, not a culture. And even the culture or weak constitution or a holy book or my horoscope is not excuse for violation of human rights. So please stop using the cultural sensitivities as excuse. And the second one is the lady from France, when you ask about the social media, and Amos already touched on this. I think the most important thing here is the fact that this infrastructure and social media are in hands of private companies, and they have decision-making over what is allowed on those platforms. So I'm not advocating for public control and state control of these platforms, but we need to have a genuine discussion in the society what standards we want to apply to those companies and what do we want them to do, because we don't want to give up our contract with the state just for a private contract with those companies, especially those that have a dominant position on the market. So we need to really engage with them and have a genuine dialogue and discussion about how those platforms should be regulated and maintained.
Thank you, Barbara. Well, with that, we'll have to conclude the IPDC talks this time around. We'd like to thank all our speakers. We'd like to thank you, ladies and gentlemen, for being here. We'd like to thank AIBD for organizing this IPDC talks, the first in Malaysia. It's a historic event, of course, in collaboration with UNESCO and Radio Television Malaysia. So from all of us here in Kuala Lumpur, it's goodbye to the next time at the IPDC talks.